Gonna go to the 8:15 review calendar. That's taken roll already. Start with alphabetically. Tempe, Yang. Ma'am, if you come up, have a seat. Howard's everything going? It looks like we need a victim impact panel by today and IOP, intensive outpatient. What's going on? Do we have that?
They're still working. Yeah.
Are you? That's always a good idea. I mean, they're still working on that. You don't have that yet. Well, of course, neither do we. So, and Milton, is Milton requiring that or what?
Yeah.
They're and I take it, where is that at the pretrial level? Is that is that a DUI? Well, you're here, and that counts for a lot. Mr. Coleman, any input? Looks like there's other issues afoot, and Ms. Yang is on. Pardon? That's.
Sorry, you said how much more time do you think you need?
Apparently she's got a DUI or a problem in Milton for which she's on scram, which indicates that it is alcohol related.
Yeah. Well,
I would think we probably better go out of like a month or something. November 7th. Would you have a hearing in Milton when now? On Tuesday. Oh, boy.
Yeah.
The important thing is now, yeah, looks like we need a victim impact panel as well as, but oh. And your first eval recommended the victim impact panel?
No,
Yeah, I don't know if you heard that or not. That was a part of the original judgment entered in the case back when we resolved it in July, I believe. Let's give you a new court date, November 7th, and we'll see how things go. Are you rescheduled for any more hearings in Milton at the time?
Yeah.
Is that a week from next Tuesday? It looks like.
yeah.
Well, let's readdress it on November 7th. Hopefully by then your eval, the new eval will be completed and we'll have a copy of it and do sign up for a victim impact panel. That can't hurt anything. And you're on scram. So that's a good thing. The important thing I think here is to whatever you need to do to make sure you're not enmeshed in a situation like this ever again. That'd be a real good idea. I'm signing an order resetting the matter to November 7th. Please make sure we have a completed eval by then and maybe proof that you've done a victim impact panel. They're pretty easy to arrange through just about everybody. So, Ms. Yang, any questions at all? I'm going to wish you the best of luck. And yeah, the most important thing is make sure you don't reoffend. Make sure you don't get in any further situations where you need to come and listen to somebody like me. Good luck to you. I want you to get a copy of today's order at the window outside the courtroom to your left, and we'll see you back here next month. Take care of yourself. Thank you. Leland Peters. Mr. Peters, it looks like you've got a hearing in Olympia Municipal Court, a new assault, same victim. What's the status of your case in Olympia? It's at pretrial. The SOC was entered back on April on an earlier assault. An SOC is premised upon no new violations. You're still at, do you have a trial date, and when is that? Of November. Mr. Peters, I'm inclined to set the matter over to November 7th. Mr. Coleman, do you have it?
You said trial was on the
21st and 2nd of next month?
Your Honor, I wouldn't mind setting this over to December 5th.
Mr. Peters, at Mr. Atfield's request, let's reset it to December. Now, very often cases that are set for trial resolve at the last minute. I don't know what's going to happen here, but let's take another look at it in December 7th. But as I indicated earlier, the SOC is, if you don't comply with that, you know what happens. Read a police report. There's no trial. There is no trial and decide whether or not you're guilty or not guilty. And for an SOC, it's not necessary that there be a new conviction. Well, let's not go into that at this time. But I'm signing an order resetting the matter to December the 5th. Hopefully we'll have a little more clarity then. Peters, any questions at all? I'd like to see you get through this and come out the other side a better human being. That's what I want to see. But you take care of yourself. We'll see you back here in December. Good luck with your other matter. So take care. Get a copy of today's order at the window. Jeff Rowe. Ooh. Mr. Rowe, it looks like you're at the, excuse me, at the end of a SOC with 250 owing and new violations besides. What do you want us to do? Mr. Rowe, was looking at the wrong entry here. The problem, yep, no, the problem is you're out of compliance, July and August with, the treatment. What's going on?
Well, I'm going every day. I'm sure. Do was.
The important thing I see is no new violations. Mr. Redfield, any suggestions? With my apologies for reading the wrong entry and,
Understand. City.
by far the most important thing is no new violations. And as long as that continues, we'll work with you. That's the hoops you have to jump through. The purpose of them is to make sure that you don't get a similar offense. As some people, it doesn't come to just a simple appearance in a gross misdemeanor DUI site, but so many people wind up injured, dead, etc. Let's reset the matter. Let's extend the jurisdiction to a full 2 years. I'd like to take another look. Let's have a hearing on December. Would it be possible December 5th? Let's reset the matter to December 5th. I just want to see how you're doing at that time. You have a date. Compliance is mandated in these things. And there's always, in some course, the possibility of jail time if you're not in compliance. But let's. That's the world we now live in. That's the world we now live in. COVID, pre-COVID is something we'll never go back to. So, Mr. O, I'm going to congratulate you on just being good and for appearing and your patience before the hearing was called. Get a copy of today's hearing. It'll have the date and time on it next time. Calendar that, and we'll take a look and see how things are in a month or two now, and hopefully the city indicated they're willing to give you time. So, and as I am too. You take care. Jerome, you as well. Take care. Good afternoon, ma'am. You pulled in a little late, and your name is? Ms. Markle, come on up and have a seat. You're here for a review on a DUI that goes back to date of violation March of this year, March 26th. But that's, I guess the issues here are no victim impact panel, and how about a UA? Where?
So,
Oh, boy. You rescheduled for November 4th.
Yeah.
Hey, you're getting there. November 4th is, yeah, that's a Monday. We have court the, November 7th. You think, well, no, we have court the November
Oh, I
7th. What we can do is reschedule this to November 7th. And if you, are caught up, with treatment and have, proof of victim impact panel, how about you don't need to appear? How's life going otherwise? It's, well, I think that's an answer many of us might give on a day like this. But hey, it's going. That's the important thing.
Yeah.
Well, fight the good fight, keep the faith, et cetera, et cetera. It's, and the important thing, you've already heard me say this, is you've been staying out of trouble. No new violations that I'm aware of anyway.
My only concern.
Yes.
I mean, I don't-
Boy.
And so
Oh, boy. Okay. Do the best you can. I can't ask for any more than that. The only really important thing, the only thing that's really gonna get you in trouble in this court is reoffending, is new violations. So, as long as you're doing the best you can, I'm not going to ask for anything more than that. Okay? You're doing well. You're doing well. It's life sometimes presents us with a number of speed bumps. That trail as we go down it.
I know.
That's it, but I'm gonna wish you the best of luck. Resetting the matter, here, go ahead and get a copy of it, at the window of Ms. Markle, and hopefully a situation will improve to the point where you have reliable transportation here to take care of yourself. Well, well, may as well, given the time, address the, shows. Number one, Ryan Hahn, SOC, with money owing. Paid $85 at the last hearing and nothing since.
City's not gonna take any action.
SOCN 84. That's this year, I trust. Just simply close the case.
I said, yeah.
Yeah, simply close. Give him the benefit of the bargain, and we'll see if he ever appears. Mr. Rigers again did not appear. And that's
Who was the council?
Doug Narrow.
Okay.
Oh, yeah, look at his withdrawal. He's the one that would appear the last couple of times and said, I can't, lost contact. with my
Yeah,
client."
yeah. I mean, 25.
So ordered. Good morning. Mick Rigers. Reckless, well, it was, yeah, and
You
apparently.
remember him?
Vaguely.
Yeah.
Remember what he looks like.
Yeah, that's Eric Valley's, client. Remember those hearings?
Yeah, and I have a civil case with Eric Valley, and
Interesting.
I mean, even worse if you can imagine.
Yeah, I can imagine. I've had, it's been a while since
Yeah.
so ordered. Number 7, it looks like the bond posters signed a declaration authorizing the payment. Yeah, payer has to sign a declaration. As long as we have that, they take the 250, refund them any balance due, and call it good.
Yeah.
SOC successfully complied with. Reports for Mr. Murphy Hendricks. He's there, he's not on our dime, he's Mason
Yeah.
County. They're Austin Sanchez. I know him from the Squally Tribal Court. He's facing the 9s. Yeah, Florida, man, they just can't catch a break. Apparently, the jail is now available for the in-custody hearings. We'll go to the jail.
There we go. Morning, Judge.
Good morning, Mr. Evercombe.
This is Chad Murphy Hendricks. He's item number 1 on the 8:30 calendar. Matter comes on for an arraignment. I've had an opportunity to review. I was provided by the city a copy of the arrest report in the matter, and he and I had a chance to review all of this, and he'd like to waive arraignment, to be read the charges in open court and all of that, his trial rights. He'd like to take care of this matter today so as not to have to come back at a later time. There's a statement of intent on plea of guilty in all courts to the second count of use of drug paraphernalia. Upon the court's acceptance of that plea, the city would move to dismiss count 1.
Morning, sir. For the record, is your full name Chad, middle initial W, Murphy Hendricks?
Yes, sir.
Mr. Hendricks, I'm appointing Mr. Haverco to represent you in this matter. Do you disagree with anything at all he just said on your behalf?
No, I do not.
I am looking at, in O courts at a statement of defendant on plea of guilty to 1 count of use of drug paraphernalia. Did you go over the plea form with Mr. Haverco? Any issues at all with the process?
What was that?
Were you able to understand what it meant to plead guilty to a criminal offense?
Yes, sir.
And if you had any questions of Mr. Haverco, were your questions answered?
My questions were answered.
Now, if I accept the plea, use of paraphernalia is a misdemeanor. The maximum penalty on conviction would be 90 days in jail and or $1,000 fine. I'd be free to impose that regardless of what's recommended. You realize that?
Yes, sir.
And if I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentence.
I understand.
Thank you. With that in mind, as to 1 count of use of drug paraphernalia, alleged to have occurred within the city of Yelm on April 8, 2024, how do you plead, guilty or not guilty?
Guilty.
Take that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty?
No, sir.
I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. The recommended sentence, as I understand it, is simply all suspended jail time on the condition you have law-abiding behavior. Mr. Haverco, anything to add?
Yeah, nothing to add, Your Honor. He's in custody. He's indigent. So based on that, that's why the city was not requesting any financial obligations.
Mr. Ratfield, anything to add?
Nothing to add, Your Honor.
Mr. Murray Hendricks, anything you'd like to tell me? You don't have to say anything, but if there's anything you want me to know before sentencing, now's the time.
Not particularly.
Okay. I'm going to follow the recommendation, 90 days, all suspended on the condition you have law-abiding behavior. And of course, you're released already on our charge. You're being held on charges from another jurisdiction, and that apparently you'll be held until that's resolved one way or the other. Any question at all?
No, sir.
That's the only condition. I'm not imposing a fine. I'm just going to wish you the best of luck and ask that if there's a issue with paraphernalia and drug usage, I'd ask you to consider addressing that. Okay.
Yes, sir.
Good luck to you, sir.
All right. Thank you. Thank you, Judge. Mr. Norton? Your Honor, this is Stephen Norton. He's got item numbers 2, 3, 4, and 5 on the 8:30 calendar.
I have the matters in front of me. Go ahead.
Thank you, Your Honor. So a couple of requests. They're kind of concurrent requests. One, we're asking to reset the matter a couple of weeks. I know he's kind of discussing this matter along with this Puyallup matter with his attorney in Puyallup. trying to figure out kind of how to resolve these cases, if at all. And in the meantime, he's also concurrently asking the court for a furlough. He believes he has treatment lined up, and you know, feels that he needs treatment, and would be to his benefit to do that. Obviously, he's in custody right now, so he can't commence with the kind of treatment program available to him while he's in custody. So he's seeking release. And for what period of time are you requesting release?
I just got approved for treatment yesterday. They're asking me for, I'm waiting for a bed date. I'm pretty sure it's with ABHS.
Okay, and do you have any idea how long the program is and when that date would be?
It would be within the next 2 weeks, and I'm not sure how long the program would be, at least 90 days, I think.
Okay. So do you have any paperwork on it or?
Not yet, I will soon, very soon.
Okay, so apparently he's had some contact with ABHS. There may be some treatment, inpatient treatment that's getting lined up. He's not sure what the duration would be, but it could be in the nature of 90 days. Do you have any idea whether or not you'd have to be released to report there, or would they come and get you?
They'd
Like,
come get me.
they'd come get you, so in a sense you'd be kind of in custody.
Yes.
Okay. So I guess the situation would be if there wound up being, documentation, I guess the situation would be if the court were to go along with this, the court could potentially release him, I guess, into the custody of ABHS. They would actually apparently, I guess, come and pick him up and transport him to the facility. Do you have any idea where the facility is? Okay, apparently the facility is in Port Angeles.
The treatment agency is willing to transport?
Apparently.
Yeah.
Yeah.
I've seen it before, so I'll see what it would be.
Is there some point at which maybe you could get them to
I just got the assessment.
get some paperwork to me and I could.
Absolutely, I already, you're part of the ROI.
Okay. So today's the next court date's the 24th, so when do you think the start date might be?
That would be, so I don't know exactly. They told me that
Would
within the next-
it be after more than 2 weeks away from today?
I'm not sure.
I guess my thought is if the bed date, my impression is the bed date might wind up being a little bit more than a little bit after the next court date. He apparently signed a release of information for me. So if I become in receipt of documentation that shows all this stuff, I can share that with obviously the city and the court. And, there may be sufficient documentation that could serve as the basis for potentially for a furlough with, compliance and conditions with the facility. So I will await that and will reach out to the court clerk and the city as soon as I receive anything and see. So I would just suggest that it probably does make sense to reset this case a couple weeks and see what kind of paperwork we get.
Feel any input? Mr. Aberco, what I'm inclined to do is reset the matter out for a couple of weeks.
Okay.
In the meantime, if bed date is arranged and that is communicated to you, I will release Mr. Norton to the treating agency with the hope that he successfully completes treatment. And I'll expect here if there's any he aborts treatment or there's any issue at all.
Okay, sounds good.
Sounds good.
All right.
I think it's a great idea, pending an evaluation. If you can get into inpatient, I'm going to release you for that. I'll furlough you for that. When it does, hopefully I'll know when treatment is projected to be complete, so I can give you a court date shortly thereafter that I'll want you to appear at.
I got approved for court yesterday, Your Honor, so I'm just waiting for the bed date now.
Perfect. It's critical that you not reoffend.
I don't want to, Your Honor. I've upset my family and I've disappointed my children, and I don't want to do this anymore, Your Honor.
As soon as I hear the good news, you have a bed date, I will email to Nisqually Jail order releasing you on the bail and to the treatment facility. I'll need to know who that is.
Yes, sir.
Thank you, Your Honor.
Take care of yourself.
Thank you, Your Honor.
Formally already set to, just to review, 24th of October.
Your Honor, this is Austin Sanchez. His item number is 6 and 7 on the 8:30 calendar. Both matters come on for arraignment. He's actually not being held on these matters. He's being held by VOC. So we would just ask to treat this as a regular arraignment and, enter not guilty pleas and set a pretrial date.
Any idea how long he's gonna be,
He thinks, yeah, he's already been in about 6, 7 days, and he thinks he won't be in more than about another 6 or 7. So it's kind of like, about maybe 15 days total, but he's already been in about a week.
November 7th? Good morning, sir. I know, but for the record, is your name Austin, middle initial R, Sanchez?
Yes, sir.
Sanchez, I'm sure you remember me. I remember you from, you have appeared in the Nisqually Tribal Court. I don't perceive that as being any conflict since I'm not representing you there at this time. But hey, if there is an issue, I want you to tell Mr. Haverco and share that with him, all right?
Yeah.
In any event, the citations I have alleged that on or about April 27, 2024, you committed the offense of driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction to be 364 days in jail and or a $5,000 fine. You're also cited for no valid operator's license without ID. That's a simple misdemeanor. Maximum on conviction to be 90 days and or a $1,000 fine. You were also cited on the same date, April 27, 2024, for the offenses of theft in the 3rd degree and obstruction of a law enforcement officer in the performance of his duties. Each of those is what they call a gross misdemeanor, the maximum penalty being 364 days each and or a $5,000 fine each. I'm appointing Mr. Haverco to represent you in these matters. He's going to enter a plea on your behalf at this time.
Yeah, thank you, Your Honor. I've had an opportunity to review the police reports actually already with Mr. Sanchez. And so we stipulate to a finding of probable cause and would ask the court to enter not guilty pleas on all counts in both matters.
Hey, Mr. Sanchez, a plea of not guilty preserves your rights. We're going to set a pretrial for November 7th. That's will be at 10 o'clock, 11.
So my next court date would be at November 7th? Is that what he's saying?
Yeah.
Okay.
We will.
Yeah,
We'll see to it that you get a copy of the order today that'll have the date on it. You're already released on our charge, and once DOC releases its hold, you'll be out. What I want you to do is note Mr. Haverco's contact information, and off record, I want you to give him your contact information. He'll need a phone number at least. Okay. Any questions at all?
Nothing.
Conditions release are the usual ones. Don't drink and drive. Don't drive without license and insurance. And any officer asks you to take a breathalyzer, you're to do so. And no drinking and driving at all. Any
Okay.
questions at all?
No.
Sanchez, good luck. Hopefully,
and I'll, before they take him back, I'll make sure to get Mr. Sanchez's phone number. And if we could just address right now,
yes.
item numbers, Jebediah Stecker, he's item numbers 8, 9, 10, 11, and 12 on the 8:30 calendar. Just for the court's information, he's no longer in custody in the Nisqually Tribal Jail. He apparently was released on the hold from Lakewood yesterday, but then he had another hold in the Thurston County Jail. And they contacted the county, they wanted him, so he apparently was transported to Thurston County Jail. So that's the information I have.
Thank you, Mr. Haverko. That concludes, your calendar in the jail. You take care. We'll see you down here in a few minutes.
Thank you, Your Honor.
So before you go, so, you have it.
Secretary in custody. I did give him a court date of October the 10th. So you know where his warrant? I'm inclined to issue a warrant, low bail. So we can give him a new court date. We'd have no idea how long the county's gonna hold the bail. 2,500 cash or bond. That concludes the 8:30. Do we have any attorney-related matters ready to go at this time? That's we'll address those at this time. Still on the record,
Good morning, Judge. I'm here on behalf of case number 4803.
so you moves to orally amended, so done. And negligent driving in the second degree, as I recall, is a not criminal, civil in nature. The parties agreed to a disposition of that charge.
Yes, we are the court line committed by agreement. We ask that impose the fine of $250.
Mr. Cole, do you admit or deny that on August 7th, 2024, you drove in a negligent manner, neg driving in the second degree?
Yes, sir, Your Honor.
Recommended sentence is the recommended fine. There is no possibility of any jail time. It being infraction is $250. I'm going to waste your time a little bit by saying that driving a car is probably the most dangerous thing you're ever going to do. You would be here till sundown if I went through all the cases I remember where clients, people on the other side died in a motor vehicle accident because when you're behind the wheel of a car, you're 10 feet tall, you're bulletproof, and you're going to live forever. It doesn't work that way. We kill thousands every year.
Mrs. Cole was on a motorcycle.
You're on a motorcycle? Remember in my motorcycle days, double what I just said, okay? That's, and of course, yeah, I did things that make me shiver when I was on the back of a motorcycle. But hey, I'm going to wish you the best of luck and your own enlightened self-interest as well. The original charge, reckless driving, excuse me, that bears license suspension time. You're dealing with insurance premiums that you're not going to want to even hear about. In your own enlightened self-interest, slow down, get there safely. Still drive the bike. Get into that time of year where that's going to be tough. Good luck to you.
Thank you.
Thank you.
Mr. Cole, I'll sign a infraction disposition. Excuse me. I should. Excuse me, talk and swallow at the same time. Signing that, Mr. Cole, get a copy of it at the window. Good luck.
Thank you.
Thank you.
Have a good day.
and 6. It looks like, whew, I think I have enough water here, and I think I'm ready to continue. That's it. Go ahead and bring Mr. Ansing up. Good morning, Mr. Ansing. We'll address your matters at this time. Good morning to you. Can you
Good
hear
morning,
me?
Your Honor.
Are you able to hear me okay?
I can hear you. Can you hear me okay?
Absolutely. We'll call your matter starting with docket number 1, Daniel Barriga. I have in O Courts a motion to continue that matter to November 21st. Is that correct?
And that's correct, Your Honor. I've had good communication with Mr. Barriga, and he's appearing through counsel today.
Perfect. City, have anything to add?
Nothing at city.
Reset the matter to November 21st. We'll send you a copy of today's order and to Mr. Barriga as well. Boy. I'm having a little, yikes, please sign. It says, please sign, and there we go. Apparently I've now in O Court signed the order twice. That's better than not at all. That brings us to Justin Mora. I likewise see a similar motion with regard to that case as well.
That's correct, Your Honor. And on that case, I've also had good communication with Mr. Mora, and he's appearing through counsel today under 3.4.
City, have any objection?
No.
Resetting the matter at the request of counsel to November 21st, 9 a.m. Signing that, or attempting to sign the document as I speak. Order signed and closed. Mr. Ansing, thank you for appearing. We'll send your client, Mr. Mora, a copy of the order as well, and to you, of course.
Thank you, Your Honor.
Talk to you in November.
I'll see you then.
Good morning, Mr. Van Vechten.
Morning, Your Honor. I can barely hear you, but I do believe I'm getting the broad strokes of it. You appear on my screen to be mic'd, muted, but I don't know if that's intentional.
Mr. Van Vechten, for some reason, you don't come across articulately. Could you repeat what you just said? I believe that's I'm looking at an order of dismissal in the courts. Go ahead.
I don't object to the motion to dismissal. I thank the city for it. I assume this is the Benjamin McLeod case.
Hearing no objection from the city, I will gladly and will at this time sign the order of dismissal.
The other matter I have with Your Honor is Mr. DeFord. I have no information regarding him.
He has not appeared to have apparently fallen out of contact with them.
I have no new information from our last hearing, Your Honor.
Mr. Atfield?
City declined to have a warrant.
City's moving for a warrant. Any objection? I would entertain a motion to set it over to give council a chance to, if the court, if council thinks that would be of any use.
If Your Honor is willing to entertain one last attempt, that would be appreciated. He occasionally still has contact with his social worker, who is still making efforts to try to persuade him to enroll in the treatment. So,
right. Why don't we set it to October 24th to give you a chance to reestablish contact? Would that work?
let me just check that, Your Honor. Would it be at the same time at 9 in the morning?
It would, yes.
then I think it would work, yes. Assuming I could appear via Zoom.
Note the non-appearance for speedy trial purposes, resetting the matter to October 24th. We'll send notice to both Mr. DeFord and to council. Mr. Van
It is
Dyke,
the 24th, not the 3rd, correct, Your Honor?
I'm sorry, the 24th, yes.
Yes, okay.
I
Thank
shouldn't,
you, Your Honor.
I'm not very good at multitasking anymore, if I ever was. Reset to the 24th of October.
Thank you much, Your Honor. With your permission, may I be excused?
I'm going to wish you the best of luck in reestablishing.
Thank you, Your Honor.
These are difficult cases. Good luck with that. Take care. of
Thank you, Your
yourself.
Honor.
Yes, sir. Well, come on up. That's apparently, I'm sorry, I didn't realize you were in the courtroom. If you didn't hear the good news, your attorney persuaded Mr. Ratfield to dismiss the case, and I signed an order dismissing the same. That takes care of the case.
So does that mean also I have to either reconcile with the woman or go through court again? You don't know.
I don't know what the situation is. If there's a no contact order in place, that will remain in effect until whatever issuing court amends that or changes that. But you're under no obligation to do anything other than abide by any existing no contact orders. And I don't know I don't know whether or not that order is still in existence. Does that answer your question?
Yes, as far as I know. Thank you very much.
And what court entered the no contact order?
Believe the Thurston County.
You might want to check, did any lawyer represent you there?
No.
What you might want to do is contact the court, that'd be family court probably, and ask them. Tell yourself, give them a call, ask them, is a no contact order still in effect?
Yeah.
And if it is still in effect,
Abide by it.
you might want to deal with it at that point.
Okay.
But Mr. McLeod, thank you I'm sorry I didn't realize you were in the courtroom, but
It's okay.
your attorney secured a dismissal, and that's usually good enough.
All right. Thank you.
You take care of yourself, okay? What honey was right? That's all we had. John Russell does not answer. How about Gianni Ross? He has not showed up on Zoom. Lokelani Villegas. Mr. Ratfield, the 9 o'clock no shows. The docket number 7 is a pro se, but without appearance. Little early, but hey, bit early than late.
Number 7.
Number 7.
About 1500.
So ordered. Next, Mr. Ross's client.
Not surprised.
I'm shocked. My jaw, I'm slack in the gate with astonishment.
I had 2,500.
As a courtesy to council,
Okay.
I'd like to reset it one time. That's
Madam Clerk, how many times has this been reset? And
I can't count that. I ran out of fingers and toes.
Reset without, because of non-appearances.
Because of non-appearances. Several, as I recall, this is that financial responsibility
Yeah, right.
issue with they're trying to sort out. I'm going to note the non-appearance for speedy trial purposes, and out of courtesy to council, reset it to the 24th of October. Send it to Attorney Kara. Send it to her, Kara, of her attorney. And the last one, Lokalani Villegas.
Oh, I'm sorry, Your Honor. You said,
Number nine. This goes back. Bail bond is posted.
I'll
We come back to that. I want to come back to that later in the day if we can.
Okay.
unfortunately, we have an interpreter, we have an appearing defendant, but we don't have the defense lawyer yet. We're just gonna have to go off record until Mr. Haverco shows up. He should be here by now. Now back on record for a 9:45 hearing, Mr. Mold. Solemnly swear or affirm that you'll accurately translate from Spanish to English, English to Spanish, all that is said here. Okay, thank you. Good morning, sir. Is your name Arnold David Ramirez Pulido?
Yes.
You're here for arraignment on 3 different charges. It's alleged that on August 15th, 2024, you committed the offenses of a false statement to a public servant, false statement to a public servant, driving a license suspended, 3rd degree. Those are misdemeanors. Maximum penalty, 90 days and or $1,000. Also cited for operating a motor vehicle without ignition interlock. That's a gross misdemeanor. Maximum penalty on conviction, 364 days. And or $5,000. I'm going to appoint Mr. Haverco to represent you in these matters. He'll enter a plea for you at this time.
With that said, Your Honor, I would stipulate to probable cause on all charges and ask the court to enter a not guilty plea to each charge.
Plea of not guilty preserves your rights. We're going to set the matter for a pretrial. Which is to determine whether or not you can settle the case by agreement.
Do you have a phone number?
Mulder, are you available November 7th, 10 or 11? November 7th, 10 or 11? No hurry. Next court appearance will be November 7th. 10? At 11 o'clock in the morning. At 10 o'clock in the morning. Stay in contact with your attorney. Conditions of release. Law-abiding behavior. Any questions?
You need to sign right here.
I'm signing an order. You'll be able to get a copy of that outside into the window on your left. Stay in contact with Mr. Haverco, and we'll see you on November 7th. And the warrants that were issued will be quashed.
I'll contact you. With the assistance of the court certified. With the assistance.
Smo, thanks much. Thank you, sir. If you make sure that Mr. Ramirez Polito gets a copy of the order, and God, you have a great day and thanks.
Give me a moment. Yes,
Back on record.
has two matters, and he's going to, we talked about whether or not he might want to try to reinstate, and he apparently may have a job now and doesn't want to come back to court. So we're going to enter a plea, straight plea to the case ending in 384. And then upon the court's acceptance of the plea, the city would move to dismiss the other suspended driving third case ending in 388. And the recommendation would be 90 days in jail, all suspended for 12 months on the condition of no new criminal law violations, and a $250 probation fee, at the end of which time the case could be closed.
Mr. Reyes, do you disagree with anything at all that Mr. Haverco just said? Do you disagree at all with Mr. Haverco?
No.
I'm looking at a statement of defendant on plea of guilty to one count of driving no license suspended or revoked third degree on August 27th, 2024. Have you gone over the plea process with Mr. Haverco? Have you gone over the plea process with Mr. Haverco? And if you had any question about what it meant to plead guilty, was your question answered?
Yes.
I accept the plea, you give up the rights in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to 90 days in jail, regardless of what's recommended. You realize that. With that in mind, as to one count of driving while license suspended in the third degree in Yelm on August 27th, 2024, how do you plead, guilty or not guilty? Do you make that plea of your own free will? Anybody make any threats or promises to you to make you plead? I'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense that you've pled to. Mr. Haverco, anything further about regarding sentencing?
No, nothing to add, Your Honor. Would ask the court just to follow the city's recommendation. It's agreed.
Mr. Ratfield, anything further? Mr. Reyes, anything you'd like me to know? Now's the time. You don't have to say anything.
It's mixed up between the insurance company and licensing, and I just gotta get it straight.
It's one of those accident cases, Judge.
Financial responsibility.
Yep, yep.
That's, Mr. Reyes, yes, that's a situation that's well worth it to have insurance, just for that reason alone, is to not get enmeshed and snared in the morass, let's say, Department of Licensing. I'm going to follow the recommendation, 90 days suspended, probation fee, monitoring fee, $250. You can pay that at $25 a month, and I'm going to wish you the best of luck getting your license reinstated. For the record, cause ending in 9388 is dismissed. But a fairly small community here, that means that, oh, hey, there goes that guy again. I know he's suspended. So hey, work on getting your license reinstated.
I think it's gonna be a matter of some phone calls, because I paid what I was supposed to, but there's stuff with paperwork and stuff I found out after the fact, and I took care of that, and then they were supposed to contact licensing, and I guess that part of it.
Between the insurance company,
Yeah.
the DOL, and you, there's the left hand very often
Getting done, yes.
hasn't any idea what the right hand is doing.
I just gotta go through and get the receipts that I gotta have a moment, a file somewhere.
Good luck. Mr. Reyes, what I want you to do is get a copy of today's paperwork at the window, okay? Any questions? Good luck to you, sir. Anything further at this time?
Let me fix it up. What's your name, sir? So this is Trenton Woodard on the 10 o'clock calendar. Parties have reached an agreement, that being a stipulated order of continuance, the matter to be continued for 12 months on the condition that he have no new criminal law violations and pay a $250 court fee, at the end of which time the city would move to dismiss.
Good morning, sir. Is your full name Trenton Schuyler Woodard? Any issue understanding? Am I speaking loud enough?
No, yeah.
Sorry, thank you. I may be a little bit weary in the voice myself. I'm looking here at an SOC stipulated order of continuance, but in reality, what that is a contract between yourself and the city, negotiated by your attorney, under the terms of which this case can be dismissed. It can go away. Whether that happens or not is up to you. That's your attorneys put you in that position, but compliance is up to you. $250 probation monitoring fee, law-abiding behavior. That would include, abiding by any no contact orders. If you abide by those conditions, the case will be dismissed. If the city proves that you violated the agreement by a preponderance of the evidence, we'll have a hearing based on the police reports, and you know what that would result in. That would almost certainly result in a conviction. You have a chance here to get this charge dismissed, not go on your record as a conviction. It's important that you take advantage of that. Do you have any questions of me? All I can do is wish you the best of luck and say, yeah, these no contact, they're pretty important. What I want you to do is get a copy of today's agreement, that at the window outside and to the left. Look it over carefully, and you have Mr. Haverco's contact information, should you have any questions. Good luck to you, sir. Yes, at the window, where you're gonna get today's agreement. Good luck to you. Thank you.
Mr. Carver, why don't you come on up?
Good morning.
So Mr. Carver comes before the court for a couple of pretrial hearings, couple of cases. Total charges of suspended third, trip permit violation, license suspension, other jurisdiction, and then suspended third. We've reached an agreement, that being statement of defendant plead guilty in the case ending in 027. He's going to enter a straight plea to the suspended driving third degree charge. And he's also going to enter a plea on the 695 case to a suspended third degree charge. In exchange for which, once the court accepts those pleas, city will move to dismiss on the 027 case, counts 2 and 3, the trip permit and the suspended license charge. So pleading to 2, dismiss 2.
Morning, sir. For the record, is your name Darren James Carver? Mr. Carver, I'm looking at a statement of defendant on plea of guilty to 2 counts of driving no license suspended or revoked on the third degree, different violation dates, May 16th and August 2nd. Have you gone over the plea process with Mr. Haverco? And if you have any questions about what it meant to plead guilty to a criminal offense, were your questions answered? Now, if I accept the plea, I'd be free to impose up to the maximum, which is 90 days and or $1,000 fine on each charge, regardless of what's recommended. And I realize the recommendation is for suspended jail time. Also, if I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, just a sentencing, and that ends the matter. With that in mind, as to 2 charges, one of driving a license suspended, revoked in the third degree on May 16th, the other driving a license suspended, revoked on August 2nd, 2024, both within the city of within the city of Yelm. How do you plead, guilty or not guilty? You make those pleas of your own free will. Anybody make any threats or promises to you to make you plead guilty? I'll find the pleas to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements and is part of the resolution. The other 2 charges will be dismissed, and that is noted in the plea form. Heard the recommendation, Mr. Haverco, anything further?
No, Your Honor. Just ask the court to follow it.
Mr. Radfield, anything further?
No.
Mr. Carver, anything you'd like to tell me? We were all guilty of that at one time or another. The important thing is you're addressing the situation, and yeah, we live in a world where it's almost impossible to function unless you're able to drive. So I wouldn't give up on just getting fully reinstated. And once you are reinstated, make sure you stay there. Make sure you're taking care of any infractions you get, and better yet, don't get any infractions. Don't give any officer any reason to pull you over. I'm following the agreement, all jail time suspended, 90 days suspended on each count, $250 fine, period. You can pay that over time. I'd rather spend your resources to reinstatement of your license. I would rather have that. If you have trouble making the fine payments or the monitoring payments, let us know, okay? We can certainly deal with that. Good luck to you. Get a copy of the paperwork today at the window, look it over, and call Mr. Haverco if you have any questions.
Yeah, yeah.
Mr. Carver, good luck to you, sir. Take care, and thank you.
Stay on the summary. Runkles?
Yeah.
Well, Mr. Tipton's here, he's got a pretrial and an arraignment, so my suggestion on that is, do the arraignment and then we can reset the pretrial case and set them together. Typically what we do since you have a new case, we enter not guilty plea to that, set a pretrial, then reset the trial. That makes sense. That makes sense. Yeah. Yeah, they're both docketed at 10 o'clock.
Ah, got it.
Yeah, yeah.
Good morning, sir. Is your full name Jason E. Tipton? Mr. Tipton, the new citation I'm looking at alleges that on or about September 23rd, 2024, you committed the offense of knowing possession of a controlled substance. That's a gross misdemeanor. First conviction would bear the possibility of up to 180 days in jail and up to a $1,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf and appoint you represent you on this matter as well.
Thank you, Your Honor. We stipulate the probable cause and ask the court to enter a not guilty plea.
Tipton, a plea of not guilty preserves your rights. I assume we're gonna have to reset both matters for a pretrial in the future.
Right. I would just ask they be, ask the pretrial matter be continued and set along with, at the same time as the new case.
Mr. Tipton, one of the conditions of release on the matter set for a pretrial today was no law violations. City have any position with regard to custody?
No.
Mr. Tipton, in some jurisdictions, you'd be taken into custody for violation of the orders in the I'm not going to do that. The conditions of release are law-abiding behavior, and that includes controlled substance use. Don't.
And before you go, just go see the clerk at the window and she'll print out the paperwork from today that'll have your next court date. Yep.
Mr. Tipton, November 7th is your next court date. Please don't be back in custody before then. This is Ivani Villegas, who I believe has walked into the courtroom. I'm not positive of that. But... Good morning, ma'am. Is your full name Logelani L. Villegas? Citation alleges that on or about December 31st of 2021, he committed the offense of being a minor in possession or consumption of alcohol. That's a misdemeanor. The maximum penalty on conviction to be 90 days in jail and or a $1,000 fine. I'm going to appoint Mr. Haverko to represent you in this matter. He's going to enter a plea on your behalf. And Mr. Haverko, I'll turn to you.
Your Honor, would stipulate to, you know, a probable cause and a guilty plea and, yeah. And do you have a phone number or anything, or would I reach out? Okay. Cool. You have the sign.
Ms. Villegas, the next hearing is November 7th, 2024. What I want you to do before you leave is go to the window, get a copy of today's order, stay in contact with Mr. Haverko, and we'll see you back here in November. Conditions of release are simply law-abiding behavior. Stay out of trouble. Appear for court as directed, and staying out of trouble includes, if you're under the age of 21, is no alcohol. Any questions at all? Ms. Villegas, thank you for appearing. Again, get a copy of the order, and we'll see you back here in November.
Then I'll be calling. Yeah, yeah.
And Mr. Haverko's information will be in the order you're going to get.
And there's only a couple of people in the courtroom. Mr. Flowers is here, but he's not scheduled until 11, and I will talk to him. And then Mr. Miguel Martinez on the 10 o'clock. I haven't been able to speak with him yet, so I'll go ahead and meet him now.
Okay. Back on record, Mr. Haverko, I'm going to defer to you for the order of
Thank you, Judge.
the matters are
Thank
called.
you. So if we could go back to the 10 o'clock calendar and call Miguel Martinez.
Miguel Martinez in the courtroom. Good afternoon, sir. Or good morning, I guess. Sorry, have a seat.
So parties have reached an agreement, that being a 2-year stipulated order of continuance. The matter to be continued for 24 months on the standard DUI related conditions, $990.50 costs. And alcohol drug evaluation, it's all in the form. At the end of which time, after 2 years, if he abides by the agreement, the matter will be amended to that of reckless driving. And then we also intend on doing on the mitigation matter is we'll admit to the improper lane usage, $150. And then the city will move to dismiss the insurance ticket and the expired cab ticket.
Mr. Hatfield, anything to add?
Nothing to add, Your Honor.
Good afternoon, sir. For the record, is your name Miguel Valentin Martinez? I'm looking at an SOC in the old court system here. Mr. Haverko has told me pretty much of what it's involved. Have you gone over the agreement with Mr. Haverko? This is a 2-year continuance. It's premised on certain things. You've given up your right to go to trial. You've given up your rights, all your trial rights, in return for a chance to get the serious charge of DUI amended to a much less serious charge of reckless driving 24 months from now. The conditions are law-abiding behavior, of course. Stay out of trouble, especially no new alcohol-related offenses. $990.50 probation monitoring fee. Do a drug and alcohol evaluation and comply with any recommended treatment. Purpose of that is to, hey, if there's a problem, let's find out what it is and let's fix it. Let's do something about it. Hopefully, turn out to have no problem and that you need to take care of it. All I can do is wish you the best of luck. A DUI conviction is kind of catastrophic in terms of impact on your life, your insurance premiums, your license, everything. I'm signing off on the agreement, Mr. Martinez, but all I want you to do is get a copy of it at the window. Read it over carefully. If you have any disagreement or question about what it meant, give Mr. Haverko a call, all right? Any questions of me? Thank you for your patience and good luck to you, sir. Take care.
Good luck. Yeah. Let's see, Mr. Cordova Jimenez.
The 11 o'clock calendar, I believe.
Correct.
Afternoon, sir. Is your full name Jonathan Cordova Jimenez? Do I have the right person? Mr.
Yeah,
Haverko?
so parties have reached an agreement, that being a stipulated order of continuance, matter to be continued for 12 months. On the condition of no new criminal law violations, $250 fee to the court, at the end of which time the city would move to dismiss.
Mr. Cordova, I'm going to repeat a little bit of what I said. You have an agreement, a contract with the city under the terms of which, if you do what you're supposed to do, this charge is going to go away. It's going to be dismissed. If you violate the agreement, you've given up your rights to go to trial, have witnesses, appeal if you lose. We'll have a hearing based on the police reports, and that would almost certainly result in a conviction for a criminal offense. Don't want to go there. You stay out of trouble, pay $250 in costs over the next 12 months, this charge will be dismissed, okay? What I want you to do is get a copy of this instrument at the window outside the courtroom to your left, read it over carefully, and give Mr. Everco a call if you have any questions. I remember the case, I remember the facts of the case. Law enforcement have a difficult time of it as it is. They never know what they're getting into when they talk to somebody or stop anybody. Always a good idea to save a lot of trouble by just being square up front. Good luck, sir. You take care of yourself. Any questions of me? That concludes the hearing. Get a copy of the agreement and call Mr. Everco if you have any questions. Good luck to you. Thank you, sir.
Next matter will be Jeffrey Flowers on the 11 o'clock.
Good afternoon, sir.
Matter comes on for a pretrial. I anticipate he's going to enter an Alford plea to count number 1. Upon the court's acceptance of that plea, city will move to dismiss count 2. He knows what an Alford plea is. He doesn't necessarily agree that he's guilty, but he agrees that based on a review of the evidence available to the city, presented along with what evidence he may have, that there's some risk that a finder of fact could enter a guilty finding. And so based upon that, he doesn't wish to contest it. He also wishes to enter the plea to take advantage of the city's plea offer, which is a recommendation of no jail time, just suspended jail time. And we would like to be heard as to the requested fine.
Good morning, sir. Is your full name Jeffrey, middle initial L, Flowers? Mr. Flowers, I'm looking at a statement of defendant on plea of guilty to 1 count of theft in the 3rd degree. That's a gross misdemeanor. The maximum penalty upon conviction would be 364 days incarceration and or a $5,000 fine. I'd be free to impose that if, regardless of what's recommended, if I saw fit to do so. You realize that. If I accept the plea, you give up the rights contained in paragraph 5. No trial, no appeal, simply a sentencing. Do you agree? With regard to 1 count of theft in the 3rd degree alleged to have occurred within the city of Yelm on January 4th, 2024, how do you plead guilty or not guilty? It's guilty, and we'll go over the rest of that in a minute. The plea is guilty. You make that plea of your own free will. Anybody make any threats or promises to you to make? I realize that this is an Alford plea, which means that you want to take advantage of the plea bargain that's been offered by the city. You don't agree that you committed anything wrong, but you realize that the matter to go to trial, things could go bad, and you want to take advantage of the plea bargain to resolve it. Find the plea to be freely, knowingly, and voluntarily made, and the factual recitation in the probable cause statement does support the factual basis for the plea. For the recommendation, Mr. Everco, anything further?
We just would ask the court to, he indicated he was working at one point because of his license status that caused him to lose employment. And so he doesn't actually have any current income right now. And in fact, it's a burden for him to pay, I think he owes $202 to the city based on another case that was amended to an infraction. So he's having a struggle to pay that. So he's just asking to not impose any financial obligations in this case.
Mr. Flowers, you have a right to tell me anything you think I ought to know or you want me to know. Now's the time. You don't have to say anything, but now's the time if you do. I'm going to follow the recommendation of the city. 364 days, all suspended on the condition you have law-abiding behavior And there's not gonna be any fine. I'm not gonna impose a fine on you. It looks like the financial, I'd like to see you get out from under. If the money's gonna be what it takes to get your license reinstated, I want you to use your money for that. We live in a world where you pretty much gotta be able to drive if you wanna function. Yes. That happens. We change our address with the, post office, et cetera, and people that send us bills and all. But rarely do we change our address with the Department of Licensing. They send out notices that never get to the person that they're sent to. Don't know what happened in your case, but that's been my experience that that's likely what happened. Don't know. In any event, I want you to get a copy of today's paperwork at the window outside the courtroom to your left. Look it over carefully, and if there's any questions, you can give Mr. Aberco a call and for clarification. I want to thank you for your patience, and I want to wish you good luck. And for the record, the second count is dismissed. Thank you, Mr. Flowers. Take care.
Next matter is gonna be, Tina Nadzak, item number 6 on the 11 o'clock calendar. Parties have reached an agreement. She's gonna enter a plea, to the charge. There's a statement of intent on plea guilty. Courts and,
Good afternoon, ma'am. Full name, Tina Marie Nadzak. If I mispronounce your name, I apologize. Plea form tells me you're 58 years of age. You've got a GED. Any issue at all? Reading, understanding the plea process. The statement I'm looking at is a plea of guilty, statement of intent on plea of guilty to one count of theft, third degree. Gone over your rights and the process with Mr. Aberco, did you? And if you had any questions, did Mr. Aberco answer your questions about the process? Now, if I give up the right, if I accept the plea, you give up the rights contained in paragraph 5, no appeal, no trial, no witnesses, no nothing except the sentencing. None. With that in mind, it's the one count of theft in the third degree alleged to have occurred within the city of Yelm on August 28th of 2024. How do you plead guilty or not guilty? You make that plea of your own free will. Anybody make any threats or promises to you that make you plead guilty? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the plea. Mr. Aberco, with regard to any recommended?
it's just a standard, recommendation by the city, all suspended jail time, 364, all suspended for 12 months on the condition of no new criminal law violations, 250 feet of the court, and at the end of which time the case can be closed.
Ms. Nadzak, you have a right to tell me anything you think I ought to know. You don't have to say anything, but if you want me to know anything about. Well, the reality of life is we all make mistakes. We all make mistakes, and the point is we get to learn from them, or if we don't, we're going to repeat them. And I hope this is just one of these things one of these mistakes that humans make when we're all human, and it's something you'll learn from. Mr. Aberco, anything to add?
Nothing.
I follow the recommendation, of course, all jail time suspended on the condition to stay out of trouble. Ms. Nadzak, thank you. Final paperwork is being prepared. You can get a copy of that at the window outside the courtroom to your left. I want you to do that and then look it over. And if there's any question you might have, give Mr. Aberco a call. That's it. Thank you.
You're welcome. Take care. Okay. Next matter would be Austin Parker.
Mr. Parker, good afternoon. I guess still good morning.
Motion to continue. We've submitted into full courts a motion for continuance. And asking to reset it at least, what were we talking about, a couple months at least? Yeah, he wants he wants to figure out, looks like, you know, it's revoked for an indeterminate period of time, but there may be a possibility of some reinstatement by way of a hearing. So he'd like enough time to contact UL and figure out, you know, what, if that's a possibility, and it could be.
It is.
You never know.
You don't,
So I know it's too
until
much.
you ask, you don't know.
Is, you just, and he just applied for the hearing. I guess my question is 2 months enough time? Should we kick it out? I mean, I don't, you know, we put in a waiver, and if the court, if no one has an objection, maybe 3
How about
months.
we set it over to December 19th?
Sure.
The last court date of the year.
Okay.
With the understanding of, look, Mr. Parker, if you need more time, come December 19th to get your license reinstated, and that's in the works and a possibility. You let me know and you've got it. That's what I really want you to do here is get your situation back where you can legally drive. That's what I want. Sign an order resetting the matter unless the city has any objection.
No objection.
No objection being heard. I'm signing the order resetting the matter to December. Mr. Parker, go ahead and get a copy of today's order. Make a note of the date. That's a couple of months from now, and we'll see where we are end of the year. Thank you, sir. Take care.
Oh, never mind. Yeah, you're free. Next matter would be Jeffrey Poe.
Mr. Poe, good afternoon. Good morning.
So, this comes before the court for pretrial hearing. Parties have reached an agreement, that being a 3-month stipulated order of continuance on condition upon him having no new criminal law violations, $250 court fee, at the end of which time the city would move to dismiss.
Mr. Poe, disagree with that? No, you got an agreement here. The charge will be dismissed if you just simply stay out of trouble for 3 months. Pay $250 by way of costs, and the thing goes away. Now, if you violate the agreement, you've already heard me say this, we'll have a hearing based on the police reports, and that would almost certainly result in a conviction for an offense. I'm cognizant of when these incidents, I'll call them, happen, and we either learn from them or we're condemned to repeat them, and I don't want that to happen. I'm signing off on the order, Mr. Poe. I'm going to wish you the best of luck, and I want you to get a copy of the agreement at the window and look it over. And as I've indicated to other people, call Mr. Haverco if you have a question. That's what he's there for. Any questions of me? Good luck to you. Take care.
Yeah, pretty good. Next matter would be Donzale Stewart. Item number 9 on the 11 o'clock.
Stuart, good morning.
So a matter comes on for a pretrial hearing on a reckless driving charge. The parties have reached an agreement, that being a 6-month stipulated order of continuance, conditioned upon no new criminal law violations, 250 feet of the court, at the end of which time the charge would be amended to speeding too fast for conditions, 4661 400.
Stuart, do you disagree with anything? I suppose for the record, Donzale, Anthony, Stewart, I'm going to repeat something you've already heard here, but I have to make sure you understand that what you've done here. It's an agreement, a contract with the city, under the terms of which you do your end. The city dumped this down to a speed too fast for conditions, which is an infraction. No jail time, simply a fine. That's the most important thing. Stay out of trouble. No further violations. The $250 needs to be paid within the 6 months. And now, well, you admit that you had expired registration. It's a 150 it is then. Now that's a reckless driving, in your own enlightened self-interest, you get convicted of that, there's loss of license, there's fines, your insurance premiums go through the roof, it's a disaster. You have a chance to get this knocked down to a speeding ticket, which is, it's not great, but it's a heck of a lot better than a serious criminal driving offense. Mr. Stewart, I'm going to wish you the best of luck. You take care of yourself. And again, I should tell everybody, if you have an issue making the fine payments, let us know. We can deal with that. Far more important that you just stay out of trouble and learn from the situation. I'll wish you the best of luck. Again, get a copy of the agreement, look it over, and call Mr. Haverco if you have any questions. Take care of yourself.
Yeah, just checking the window before you go. Yep, here you go. Oop, that. You too. Next matter would be, last name is Velasquez Allende. First name Carmen. Matter comes on for the court for a pretrial hearing for assault, fourth degree, domestic violence. I've reviewed the reports with Ms. Velasquez Allende and had, based on that, had a discussion with the city. And based on that, I believe the city has a motion. This is the child case.
Oh,
Carmen,
city's moving to dismiss.
I hear no objection to the motion to dismiss the charge. Is it Carmen Velasquez Allende? It's a. Hey, what I'm going to do is wish you the best of luck. Family situations come up, and we can all learn how to resolve those situations better than we have in the past. All of us. I'm going to wish you the best of luck as things move forward in your life. But this charge is dismissed. It will not appear on your record as a conviction, and you take care of yourself, okay?
No, here you go.
And I'm preparing
Ma'am, I'll sign the order upon presentation. It'll show up on the screen here in a minute. If you need a copy of it ever, you can get a copy at the window. Thank you, ma'am. Take care.
Hey, Paul, why don't you? Oh, okay, let me see if I've talked to the guy. I don't know. Let me take a look. Oh, yeah, I did. Yeah, okay, yeah. We doing that now, or what, which you? Whichever, okay.
Good morning. Mr. Scott, how are you? For the record, Paul Harvey Scott.
Yeah. Matter comes on for, looks like three, two pretrial matters and then an arraignment matter, Your Honor. And he is late. Technically, it's a failure to appear. I would just then note for the record, based on that failure to appear, that's would apply for speedy trial purposes. So I would suggest we proceed with the arraignment and then set a pretrial date and then continue the other two pretrial matters along with the new matter.
Again, for the record, Paul Harvey Scott is your full, true, and correct name.
Yeah.
Citation alleges on or about September 19th, 2024, you committed the offense of disorderly conduct. That is a misdemeanor. The maximum penalty on conviction to be $1,000 and or a 90 days incarceration. I'm going to appoint Mr. Haverco to represent you on that case as well as your earlier cases. He'll enter a plea on your behalf at this time.
Would stipulate the probable cause, Your Honor. Ask the court to enter not guilty plea.
Mr. Harvey, plea of not guilty has been entered on your behalf, which reserves your right. I understand you were given a ride here. Did you get any new citation at all today? Okay, good. Scott, we're setting the matter to November 7th. You know, I'm pretty sure that if you hadn't been, a law enforcement officer hadn't found you and brought you to court, that you wouldn't have showed up. You're thinking about it or on your way here? That's, we're resetting the matter anyway, no warrant, but I try to show up on time, okay?
So is he free to go? Yeah, you're free to go. Just
Scott,
go-
you're free to go.
Yeah, just go to the window before you go and pick up a copy of your free paperwork. Well, you have a pretrial for criminal trespass, second degree, loitering, related to drug-related activity, and then a new charge of disorderly conduct. Yeah, so yeah, go and see the clerk at the window, and I'll see you at your next court date. I guess.
Mr. Scott, never mind.
What do you have touching on?
Probably a road. Maggot.
Oh, you didn't. Get a couple.
What number was that?
Hello,
Good morning.
good morning.
Parties are conferring. They'll be with you in a minute.
Oh, okay. Sorry,
Here, identify yourself by name for the record, if you would.
my name is Emmanuel Webster.
Hey, thank you, sir. I'll turn to Mr. Haverco, your attorney.
Yeah, thank you, Your Honor. So I've had an opportunity to speak with Mr. Webster about his case and review the police reports with him. And so based on that discussion, parties have had discussions and we're proposing that the court accept a stipulated order of continuance. There's one in Oak Courts, the matter to be continued for 12 months on the condition there be no new criminal law violations, $250 fee to the court, at the end of which time the city would move to dismiss.
Mr. Webster, this is a contract under the terms of which if you stay out of trouble for 12 months, pay $250 in costs, the charge of theft in the third degree will be dismissed. Now, in return for that agreement, you've given up your rights to go to trial, have witnesses appeal. If you violate the agreement, we'll have a hearing based on the police report in your case, and that'll almost certainly result in a conviction for a gross misdemeanor. Now, you're not present in court, but we'll be mailing you a copy of today's agreement. I want you to look it over carefully and then call Mr. Haverco if you have any questions, okay?
Yes, sir.
Do you have any questions of me?
No, sir. No, Your Honor, I don't.
Okay, Mr. Webster, I want to thank you for appearing. Good luck to you. You take care of yourself. I assume we have a good mailing address, Donnie? Let's make sure we have your right mailing address so we can send you the
Okay, it's 1262.
we have that.
Oh,
1262.
okay. Yep, that's the one.
Mr. Webster, thank you for appearing. That concludes the hearing. You can sign off. Good luck to you. Take care of yourself.
Thank you so much, Your Honor.
Thank you.
Okay.
Did Your Honor want to do, FTA stuff or later? Man.
Go to the no-shows?
Yeah.
I think.
Yeah, on the 10 o'clock, the last information I received regarding Demetria Dotson was, I believe it was a communication from her mother, and my notes indicates that she was going to be in treatment until sometime in early January. There may be some other information received by the court. So with that, I would ask that the court set notice, just note the non-appearance for speedy trial purposes and send new notice for after that date.
Yeah, no objection.
We'll note the non-appearance for speedy trial purposes. We're not going to issue a warrant at this time, but simply reset the matter to April of next year if we can. I don't have a calendar for that, but I assume that we get that. And send it to the last note, transmit that to the treatment agency. Don't want to interfere with anybody's treatment.
Next matter by Brian Erickson. I looked in the docket. It's just basically kind of an old FTA case. I've never had any contact with the guy. I don't have any current contact information. I have no way to contact him. I simply just have no information as to his presence or whereabouts.
He finally posted a bail. City moved to forfeit bail posted, or the bond posted, whichever it was. Notice to the bonding company, new bail warrant will issue 1,500 cash or bond.
On the next no-show is Mr. Brett Wynn. Man, he's got bail posted too, but I don't have any current contact information. I think this is a situation where this is somebody who didn't have a phone number. I was talking to him at court and I don't have any way of contact.
Posted bond, same motion, bond is forfeited. New warrant, 1,500. These bonding companies are kind of relentless and
on the 11 o'clock, there's a Dennis LeBlue with a couple of cases, and my notes show he FTA'd on 8/1 and he FTA'd on 9/12, and the number that I did have for him is now no good. So when I call the number, it's not a good number. I don't have any information one way or the other.
1,500.
so ordered.
And David Lipscomb, he is in the county jail. I looked him up at least the other day and, yeah, it's not a ton of bail, but it's like $4,000 each charge. So
Oh,
it's like
boy.
about 16 grand or 20 grand. -ish.
1,500. 1,500 cash or bond. And with that bail, he may be in county or other places for quite
Yeah.
some time to come. We are getting started a little later than I wanted to, had a situation to take care of. We're here now, we'll get started with the 1 o'clock arraignment. We're now on record. You're here for your first appearance after receiving a criminal citation. I will eventually call you up one at a time to enter a plea. Before I do that, I need to advise you, you have a right to have a lawyer represent you at all stages of any criminal proceeding. Mr. Haverco is our public defender. He's going to enter a plea on your behalf, and he will represent you throughout the course of your case if you're indigent and request his services. Plea of not guilty is entered. We'll set it for a pretrial. Pretrial gives you a chance to resolve the case if you can. If you can't, you have a right to a public and speedy jury trial. Sarah Anderson. I'm going to call a number of names. People won't appear. After I talk to each of you, I'll review the files. If there was probable cause for the issuance of the citation to the non-appearing person, they get a warrant for their arrest. So you saved yourself a warrant for your arrest just by showing up, and for that I thank you. Sarah Anderson does not appear. How about Marcos Apodaca? Sir, if you would, step forward and have a seat next to Mr. Haverco, would you? And if I mispronounce your name, I apologize. How do you pronounce your name? Full name, Marcos, middle initial A, Apodaca. Citation alleges that on or about September 30th, committed the offense of knowing possession of a controlled substance. That's a gross misdemeanor. The maximum penalty on conviction. First offense would be 180 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf and represent you if you're indigent and request his services. Mr. Haverco?
Stipulate probable cause, Your Honor, as the court to enter not guilty plea.
We have not guilty, preserve your rights. Pretrial is going to be set for November 7th. I'll say this to you and everybody else in the courtroom. An order will be generated in connection with today's hearing. What I want you to do before you leave is go to the window outside the courtroom to your left. You'll be given a copy of the order. It'll have Mr. Haverco's contact information on it. It'll have your next court date and time on it as well. It's important that you leave here with this. And any conditions release are on that. As a general rule, the only condition of release, unless there's other circumstances, are law-abiding behavior, stay out of trouble, appear for court as directed, and stay in contact with your attorney. And if you have any questions, I'm here to answer them, if I can. Mr. Apodaca, any questions? Concludes the hearing. I have to electronically sign.
Close the window before you go.
James Bittner. Does not answer. How about Jordan Matthew Carey Barrow? Joycey Lee Cohen's Lyons. Lydia Dawson. Full name Lydia Elise, is that pronounced right? Dawson. Ms. Dawson, the citation I have alleges that on or about September 23rd, 2024, you committed the offenses of theft in the 3rd degree and criminal trespass in the 1st degree. Each of those is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf and represent you in this matter.
Stipulate probable cause, Your Honor, as the court to enter not guilty plea.
Ms. Dawson, a plea of not guilty preserves your rights.
Okay.
Pre-trial, again, it's November 7th, 10 o'clock in the morning. Conditions released, simply law-abiding behavior. And that would include, of course, not going any place from which you've been trespassed. Ms. Dawson, I'm signing today's order.
Yeah, just go to the first window before you go. Yeah.
Thank you, ma'am. Van Ehrlich in the courtroom? Mr. Ehrlich does not appear. Joshua Anthony Ennis? How about John Grantham? Forrest Hoover? Mr. Hoover, if you come forward, have a seat. Citation alleges in honor about October 5, 2024, you committed the offense of driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea. Do you have a phone number?
Mr. Hoover, I understand you have a DUI or did have one up in Alaska within the last few years. Conditions of release are law-abiding behavior, don't drive unless licensed and insured, no drinking and driving at all. Anybody asks you to take any officer asks you to take a breathalyzer, you're to do so.
Okay, that's good. So you're free to go, but go see the clerk before you go. She'll give you copies of your paperwork, my contact information, and your next court date. Yeah.
Mr. Hoover, thank you. Eileen Marie Kaume, Kaume. Very likely mispronouncing that. How about Corey Justin Keene? Does not respond. Matthew Kirky. Jeffrey Robert Kirkwood. How about Lynn Mackey? Good afternoon, Ms. Mackey. I'm going to say something here that's going to apply to maybe other people in the courtroom. Lynn Alexandra Mackey is your full name. Citation alleges in honor about September 30th, 2024. You committed the criminal offense of failure to transfer title within 45 days of achieving ownership. The city generally amends that charge from a criminal offense bearing the possibility of jail time to a civil infraction. The infraction would be expired tax. You don't plead guilty or not guilty to an infraction, you admit it or deny it. If you admit that you drove without incorrect tabs when you were cited on September 30th, I'll fine you $150. If you deny it, we can set it for a contested hearing that'll take place in a later time. Now, any questions about what I just said? It was quite a bit in a short period of time.
I believe you.
You do have the title now,
Yes,
and but it wasn't transferred when you were cited.
it had not been transferred.
Well,
This is,
you've taken care of it, and that's the good thing. If you admit the infraction, it's $150. If you deny that you committed the infraction of expired tabs, city's position would be that when you were stopped, title hadn't been transferred, tabs weren't any good.
tabs are good in the title.
Good. That's I'm glad to hear. Do you admit or deny the infraction?
Standard practice. It's done.
Standard practice where?
Tonight, I was coached last time I came to you.
You have a right to deny it, and that's what I'm hearing is a denial. We'll set the matter for a contested hearing. That'll be on November 7th.
Is your,
That has been scheduled for November 7th at 2:30 in the afternoon. What I want you to do is get a copy of today's order. That gives you your hearing time and date. You can get that at the window. Okay, thank you. Hearing is concluded.
it's up to you. He said it for a contested hearing because you didn't want to admit it. So,
Mr. Mackey, we have a number of people here waiting. I'm not going to have a hearing right now. Please get a copy of today's order at the window, and I'll see you back here on the 7th. Have a nice day.
yeah, just go see the window. Yeah, see them. Yeah.
Jeffrey Pruitt. I will always find a way to mispronounce a given name. Jeffrey Brandon Pruitt. Mr. Pruitt, you're cited for the offense of driving under the influence of intoxicants on October 3rd, 2024. That's a gross misdemeanor. The maximum penalty on conviction, 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverko to represent you in this matter. He'll enter a plea on your behalf at this time.
Stipulated probable cause, Your Honor, ask the court to enter not guilty plea.
Question, man, spoke with you when I was.
Yes. Ignition interlock, yes. That's good enough for me. That's good enough for me. Fine.
You have a phone number?
Yes.
Yeah, Mr. Pruitt, as long as we have on file, make sure we get a filing once it's installed, okay?
What do you mean?
File proof of that it has been, so they'll give you a sheet of paper that you can give us. And the other conditions, of course, don't drive unless licensed and insured, don't drink and drive at all. Good luck to you. Next appearance set for November
Wait a
7th.
second, we gotta have you sign, but.
Everything is done on the old court system now, and it's being a cyber dinosaur. I could do it a lot faster just by,
Sign on it.
but that's not the world we live in anymore.
Yep, we're good. Yeah, just.
Mr. Pruitt, thank you for appearing. You take care. Don't forget to get a copy of the order. Stay in touch with Mr. Haverko, and we'll see you back here in November. Take care. How about Kirk Reynolds? Kirk Reynolds. Mr. Reynolds, Kirk David is your first name. You were cited with driving a license suspended or revoked 3rd degree. Same situation applies to you. That is a case where the city customarily amends the charge, and I see from the criminal offense of driving a license suspended or revoked 3rd degree to the civil infraction of NVOL, no valid operator's license, 2nd degree. That's a civil infraction. The difference is the criminal offense, you could go to jail if convicted. It bears up to 90 days in jail. Civil infraction, I can impose a fine, and that's all I can do. The fine I customarily impose is $150. And now, do you have any question about anything I just said?
I do not.
Do you admit or deny?
I admit.
It'll be $150. I'll sign infraction disposition order at this time on that. Now, do you know what you need to do to reinstate your license?
It's money.
That, it's real easy to lose a license and it's a lot harder to get it back sometimes. But I don't give up. I'm gonna urge you to, do what you can to get your license reinstated. Sign electronically an order, setting the fine at $150. Make the payments at $25 a month. Once you get a copy of that, order at the window. And, if you have any issue making the fine payments, let us know. I'd rather have you spend your resources taking care of what you need to get your license back. That concludes the hearing. Go ahead and get a copy of that, and hey, you take care of yourself, Mr. Reynolds. Yeah. How about Robin Rogich? Good afternoon. Full name, Robin, middle initial D. Rogich? Did I pronounce that right? Did I pronounce your name right? Okay, thank you. Citation alleges that on or about October 1, 2024, you committed the offense of DUI, driving under the influence of intoxicants. That again is a gross misdemeanor, the maximum penalty on conviction, 364 days in jail and or a $5,000 fine. I'll appoint Mr. Haverco to enter a plea on your behalf, and he'll represent you in this matter.
Stipulated probable cause, Your Honor, ask the clerk to enter a not guilty plea.
Ms. Rogich, a plea of not guilty does preserve your rights pending a pretrial. Conditions release are law of any behavior, don't drive unless you're licensed and insured, don't refuse to take a breathalyzer if asked to do so, and no drinking and driving at all, okay? Pardon? I'm sorry, I need to slow down a little bit, yes. Not with anything I've done. That is a departmental licensing issue. And now that is something you need to talk to your attorney about. That's what you need to talk to him about. He doesn't have time to consult with you now, but I'm going to sign an order that'll have his contact information on it, and we'll be here for quite a little bit today, but maybe tomorrow give him a call and talk to him about the licensing issue.
Yeah. So do you have a phone number? Okay, thank you.
Rogich, thank you. You take care of yourself. We'll see you back here in November, okay? You take care. Sarah Shalhoub? I do not see. Sydney St. Marie. Good afternoon, ma'am. The same thing applies to you. You were cited for the offense of driving a license suspended or revoked, 3rd degree. Now, the city is nodding. They have amended the charge to NVOL, no valid operator's license. The infraction, if you admit the infraction, I'll fine you $150. If you deny that you committed the infraction, you're entitled to a contested hearing at a later date. Any question about anything I'd like to, you admit or deny? I'll impose a $150 fine. Now, do you know what you need to do to get your license back? I'd make that a project in life. Kind of hard to function in this world without a driver's license. So I'm signing the order, reducing it to NVOL, no valid operator's license, and setting the fine. If you have trouble making the fine payments, make sure you let us know, okay? Any questions? Concludes the hearing. You take care of yourself. Nicholas Tayon or Tajon? Dome? It's a Nicholas A. Dome. Citation alleges that on or about September 2nd, 2024, you committed the offense of criminal trespass, second degree, simple misdemeanor. The maximum penalty on conviction would be 90 days in jail and or a $1,000 fine. Mr. Jones, I'm going to appoint Mr. Averco to represent you in this matter. He'll enter a plea at this time.
Stipulate the probable cause, Your Honor, ask the court to enter not guilty plea.
Pretrial date to be November 7th. Stay in touch with Mr. Averco. Law-abiding behavior, no criminal law violations are the conditions of release. Any questions at all? Thank you for appearing. I've signed the order on today's hearing. See you back here in November. Take care of yourself.
Before you go. So go check in with the clerk before you go.
Thank you, sir. Take care. Robert Williams does not answer. How about Megan Willoughby? Ms. Willoughby, you got the same citation, driving a license suspended, revoked, third degree. The city is moving to amend to the civil infraction of NOVAL, NVOL, no valid operator's license, second degree. You admit the infraction, it's 150, you deny it, you have a right to a contested hearing, which we will set. If you need a moment to talk to Mr. Averco.
What's that? Tell the judge, so it's not, they're amending it to a civil infraction, so it's not a guilty or not guilty.
Pardon? Not committed. That's got it. We'll set it for a contested hearing, and that'll very likely be on November 7th. Hey, hold on, we need to, not quite done yet, need to prepare and November 7th, 2024. I'm now signing the order on today's hearing. Ms. Willoughby, you can get a copy of that.
You don't need to sign it.
And I'll want you to get a copy of that at the window outside the courtroom and to your left. You take care. Jared Wilson. Mr. Wilson, you've got the same site, driving a license suspended, revoked, third degree. I'll turn to the city as to whether or not they're moving to amend to NVOL, no valid operator's license, second degree, the infraction, if you admit it, it's 150, you deny it, that's you can set it for a contested hearing. Any question about anything I've just said? As indicated, I will impose a $150 fine, Mr. Wilson. And I guess what I'll ask is, do you know what you need to do to reinstate your license? I'd make that, I can't tell you how to live your life, but I'm going to suggest you make that a project. Unfortunately, we live in a world that's kind of hard to function without being able to drive from here to there. We all have friends and relatives, but none of them appreciate being a chauffeur for all that long. But Mr. Wilson, I've signed the today's order. You can get a copy of that at the window outside the courtroom to your left. Good luck getting reinstated. Take care of yourself. Joshua Wolf. Josh Wolf. Is it Joshua Harold Wolf? Mr. Wolf, the citation alleges that you committed the offense of criminal trespass, first degree, on September 23rd, 2024, within the city of Yelm. Mr. Wolf, I'll appoint Mr. Haverco to enter a plea on your behalf at this time.
Stipulated probable cause as court to enter not guilty plea.
Mr. Wolf, not guilty. Wolf, I've now signed the order. What I want you to do is get a copy of that order at the window outside the courtroom to your left, and be back here on November 7th, and stay in touch with your attorney, okay? You have a good day. Well, I'm not out of people, but I'm out of docket, so evidently I didn't call names that I should have called. Pardon?
Adam Jones.
Oh, is it?
It said on the 24th. I think, did I talk to you and you were in custody?
No,
Huh. Sure.
We have a Joycey, last name Cullen.
Cullen's Lions,
Yeah.
docket
Cullen's
number
Lions.
6, I believe.
Yeah. Yeah.
Ma'am, come on up and have a seat.
City's moving to.
Is your full name Joycey Lee Cullen's Lions? Ma'am, that's a citation is that you committed the offense of driving a license suspended or revoked third degree on September 27th. City, as a standard motion, they're amending the charge to the civil infraction of no valid license on your person. Now, if you admit that, I'll impose a $150 fine. If you deny that, we can set it for a contested hearing. First, do you have any questions about anything I've just said? What would you like to do, admit or deny? I'll set the $150 fine, and that'll conclude the matter. and I'll ask you, do you know what you need to do to get your license reinstated? Money. It's always money, and here we're adding to the misery. I'll assess. It being a civil infraction, I can't appoint a lawyer to represent you, but I'm not aware of the status of legal services these days. Mr. Haverco, do you know anything about, there used to have Puget Sound legal aid? I'm not sure what's available anymore.
Oh, yeah,
There's a justice project.
yeah, I'm not sure what kind of work they do.
I do know that they deal with people whose license is suspended, but I don't know if they could be of any help in this situation. And I don't have the contact information for them. This phone's line, I know there are services available, but I'm not able to direct it to. There is a justice project that deals with exactly the type of thing you're talking about, a suspended license for one reason or another. But I'll want you to get a copy of today's order at the window outside the courtroom and to your left. And
So you're free to go. Yep.
hey, thank you for appearing and good luck. Sure, come on up. What? That's a pre-trial. That's a citation. That's an order. Yeah, that's it. I tell people to, go to the window, get a copy of your order. It'll have you, that sometimes that.
Well, I just did one,
No,
And
you're
you
fine.
received that after the 26th? Oh, okay.
No, that was the original citation. Well, they got chunk. No, usually at a hearing, there's a motion to exonerate, and sometimes they exonerate it. It doesn't have to wait until the final disposition, but at the next hearing, that's what we'll do. We'll address the bail issue. That's the fact that you are here today impresses me very, very favorably.
Yeah.
Because
That's
the point of bail. Some people without bail, they wouldn't show up at all. We get that, but you're showing up. I'm hoping it's just because you want to resolve the matter, not necessarily just because of the bail. Okay, but now, as long as you were straight on what, you're back on the 24th? Please. Yeah, go to the window and get a copy. That's it. Sir, in the back of the courtroom, you have well, hey, come on up. We can address that at no. No, he just gets mad at me he just gets mad at me when I do. Yeah, that's Mr. Irinella.
Yeah, well, I'm with Mr. Scow. I work with.
Okay. And she's getting I don't have that since it's early. You're gonna be out of here early as well. That's but I presume I'll listen to any preliminary motion you have at this time.
You wanna wait for that?
No, no. If I need to, I can always review.
So, there's 300.
Yes. And I don't have any 6-6 affidavit with regard to the reliability. In any event, I'm going to grant the motion with regard to the speeding ticket. Then there's the other infractions, NVOL with valid ID, and then expired registration.
Yes, Your Honor, and both of them.
The motion is well taken. I don't see any foundation at all, other than the fact that that's if I get a citation, the defendant possessed stolen property, I need to know a little bit more about it. Such is the case here. I'm going to grant the motion and dismiss L3. We actually do generate an order in connection. And sometimes those are useful to send to the client. I'll sign the order of dismissal with regard to the infractions at this time. That concludes the hearing, and have a good day. It looks like the sun is out. Michelle Hoob, as long as you're here, why don't we deal with this? That way you won't have to, come back any more than necessary. Let me find your file here.
I don't remember, do you have a phone number or not really, or hang on a second.
Crim Trust 2.
Criminal trespass, what's your phone number? Which is the. Phone absent.
Go back on record. We're on record. I'm going to recall a matter that was set for 1 o'clock, but unfortunately, cars break down and people can't get here. Good afternoon, ma'am. Is your full name Sarah, middle initial F, Shalhoub? You're here for an arraignment. That's your first appearance after the issuance of a criminal citation. Before I take a plea, I need to advise you, you do have a right to have a lawyer represent you at all stages of any criminal proceeding. If you're indigent, can't afford a lawyer, I will appoint Mr. Haverco to represent you throughout the course of the matter. In any event, he will enter a plea on your behalf today, regardless of whether you're indigent or not. At the first court appearance, typically, invariably, a plea of not guilty is entered. That plea isn't any great statement about the case. It's simply the legal way of preserving your rights pending what they call a pretrial conference. Pretrial conference is a chance for you to discuss your case with your attorney, and he in turn negotiate with the city's representative, Mr. Garrett Ratfield, who's seated over here to my right. If an agreement can be reached regarding the disposition of your case, that's put on the record at the next hearing. If the parties can't agree as to the disposition, you have a right to a public and speedy jury trial in the county in which the offense is alleged to have been committed. I'm looking at a citation dated September 30th, 2024. It alleges that on that day you committed the criminal offense of criminal trespass, second degree. That charge is what they call a simple misdemeanor. Maximum penalty upon conviction to be 90 days in jail and or a $1,000 fine. Any question about the charge? Any question regarding any penalties? I will appoint Mr. Haverco to represent you. He'll enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Michelle Hoob, plea of not guilty does preserve your rights. Pending a pretrial, what I want you to do is Michelle, this isn't the first time you've been in front of me. Condition of release is law-abiding behavior. That means, of course, it includes don't go places where from which you've been trespassed. Okay. I'll sign the necessary order. What I want you to do is to have a seat in the courtroom. That needs to be transmitted to the office, and they'll need to print out a copy of today's order. Today's order will have the conditions release, which are simply law-abiding behavior. Stay in touch with your attorney and show up when you're directed on time, hopefully. And finally, any questions? Sure, go ahead and have a seat. That concludes the hearing, and we'll bring you out a copy of the order you'll need. Pardon? If your choice, sit in the courtroom if you're more comfortable. It's out there, wherever you want. Doesn't matter. Go check and see if that shouldn't be too long.
Out of here?
Yeah.
Golden ropes. I think this was supposed to be amended. We just did, I think, as I recall, that we were just amending for representation. A non-dragon charge. Non-dragon. Yeah, I think so. Must be my bad in terms of how I put it.
No, I know.
Right. It would be, if I start out at the beginning.
I think you would. Yeah, you know. Back on record for the 1 o'clock no-shows. Number one, Sarah Lee Anderson did not appear. I found probable cause for issuance to her of DWS third and no ignition interlock when she was spoken to in custody. Warrant will issue 1,500 cash or bond. Next no-show I have is docket number 4, James Bittner. And number 5, Carrie Barrow. Amend each of those to no vault 2 and FTA. Pardon? Oh, amend that to, I'm sorry. No vault 2 and failure to transfer to expired tabs. I'm sorry, I started to do that, then I was interrupted to talk to these guys and didn't finish up. The next one I have is Than Ehrlich. Found probable cause previously when she was spoken to in custody. 1,500 cash or bond. She was quite certain she'd be here.
You were, there was a guy with an Alaska prior DUI, but it was a different guy.
I was mistaken as
Yeah,
to,
but there was one.
there was one.
Yeah, there was, yeah.
I knew it was a DUI and I
Yep.
thought,
Yep.
I'm not having a good day, as you can imagine. Not having a good day. So I'm gonna need some time with my dog tonight. And she's she got a couple of pretty good punctures.
Yeah.
Next is Joshua Ennis. I find probable cause for the issuance to him of the 3rd degree. Next one, number 10, John Grantham, amend to no vault 2 and FTA. 12 and 13, there's a note in the file, note the non-appearance for speedy trial purposes, reset it with a notice to be sent to Ms. Miley. Bond is posted. Oh, yeah, it's a 2021 case. And docket number 14, but I was hoping something would happen on that. Forfeit the bail and issue a warrant in the amount of 1,000, probable cause having previously been found on the previous FTAs. Matthew Kirky, amend to no vault 2 and FTA. Kirk Wood, Jeffrey Robert, amend to no vault 2 and FTA. There's, the next one I have is Robert Colton Williams. I couldn't find a file on the. Oh. Oh, okay. Okay, strike. Let's strike the hearing. And I think that is it on the no-shows. Let's go off record.